So we're back at it. This is the third installment, I believe, of reading the Constitution Annotated Analysis and Interpretation of the U.S. Constitution. We are now at Intro 3.1 Ratification of Amendments to the Constitution generally, under the Section 3 Background on the Amendments to the Constitution. So here we are. We're getting started. We are devoted to that information freedom, freedom of information for the people. We are getting that information out there. I'm doing my part. I'm probably not going to reach anybody, but you know what? I don't need to care. I need to just do it because I need to read this for myself, and I might as well share it with somebody while I'm doing it. So if I'm doing a public service, great. If I'm not, fine. Leave me alone. I'm doing it because I'm lonely. Not lonely. I got things, but I just want to do this. So I don't know why I feel compelled. All right. So ratification of the amendments in the Constitution generally. The essays that follow discuss the ratification of the amendments of the Constitution of the United States of America, along with the text of the amendments, literal print. In Dillon v. Gloss, 256 U.S. 368, 1921, the Supreme Court stated that it would take judicial notice of the date on which a state ratified a proposed constitutional amendment. Accordingly, the court consulted the state journals to determine the dates on which each house of the legislature of certain states ratified the 18th Amendment. It therefore follows that the date on which the governor approved the ratification, or the date on which the Secretary of State of a given state certified the ratification, or the date on which the Secretary of State of the United States received a copy of said certificate, or the date on which he proclaimed that the amendment had been ratified, are not controlling. Hence, the ratification date given in the following essays is the date on which the legislature of a given state approved the particular amendment, signature by the Speaker of the or presiding officers of both houses being considered part of the ratification of the legislature. When the date is not available, the date given is that on which it was approved by the governor or certified by the Secretary of State in that particular state. In each case, such fact has been noted. So it's going to let us know how it's determining the ratification dates. It's very important to know. We got to know. Dillon v. Gloss said, we have to take notice of the date on which the state ratified the proposed constitutional amendment. Because if your ex was before that time, you got away with it. I don't know what this case is. We may read it later. We got to know later, but we're getting a general overview here. That's what we're here for. We're looking at it. We're getting it done. We're looking at it. We're getting it done. We're looking at it. I'm going to stop doing that now. All right. Has been noted. Except as otherwise indicated, information as to the ratification is based on data supplied by the Department of State. Brackets enclosing an amendment number indicate that the number was not specifically assigned in the resolution proposing the amendment. It will be seen accordingly that only the 13th, 14th, 15th, and 16th Amendment were thus technically ratified by number. Understand? So now we get to dive in here. Now this is the Bill of Rights, 1st through 10th Amendments. So we're learning. This is 3.2. On September 12th, 5 days before the convention adjourned, George Mason and Elbridge Gerry raised a question of adding a Bill of Rights to the Constitution. Mason said it would give a great quiet to the people, and with the aid of the state's declarations, a bill might be prepared in a few hours. But the motion of Gerry and Mason to appoint a committee for the purpose of drafting a Bill of Rights was rejected. They said, nah. Again, on September 14th, he's like 2 days later, Charles Pinckney. Now, this is Charles Pinckney and Gerry sought to add a provision that the liberty of the press should be inviolably observed. But after Roger Sherman observed that such a declaration was unnecessary because the power of Congress does not extend to the press, this suggestion, too, was rejected. So, the power of Congress does not extend to the press. What the hell does that mean? Alright. It cannot be known accurately why the convention opposed these suggestions. Can't be known. Perhaps the lateness of the convention, perhaps the desire not to present more opportunity for controversy when the document was forwarded to the states, perhaps the belief asserted by the defenders of the Constitution with the absence of a Bill of Rights became critical that no bill was needed because Congress was delegated none of the powers which such a declaration would deny. Perhaps all of these contributed to the rejection. In any event, the opponents of ratification soon made the absence of a Bill of Rights a major argument, and some friends of the document, such as Thomas Jefferson, strongly urged amendment to include a Declaration of Rights. Several state conventions ratified while urging that the new Congress would be convened propose such amendments. 124 amendments, and all being put forward by these states. Although some dispute has occurred with regard to the obligation of the first Congress to propose amendments, James Madison at least had no doubts and introduced a series of proposals. So James Madison's like, look, we got to propose. Don't leave it up to the states. We're here. We're drafting this Constitution. Let's propose the Bill of Rights. Let's go ahead and do it. James Madison's like, look. Which he had difficulty claiming the interests of the rest of Congress in considering. He's like, look, guys, we have to do it. Let's put forward something. They're like, nah, I don't really want to think about it. Let's leave it up to the states. They got it. They know what they want. And then he's like, guys, at length, the House of Representatives adopted 17 proposals. The Senate rejected 2 and reduced the remainder to 12. Which were accepted by the House. Consequently, the first 10 amendments, which were commonly referred to as the Bill of Rights, along with one that was not ratified and one that was not ratified, I guess, at all, and one that was not ratified until 1992, were proposed by Congress on September 25 of 1789. When they passed the Senate, having previously passed the House on September 24th, they appear officially in 1 Statute 97 of 1789. Ratification of the first 10 amendments was completed on December 15th of 1791, when the 11th state, Virginia, approved these amendments. There being then 14 states in the Union. The several state legislators ratified the first 10 amendments of the Constitution on the following dates: New Jersey, November 20th, 1789. Maryland, December 19th, 1789. North Carolina, December 22nd. South Carolina, they took Christmas and the New Year off. They said on January 19th, 1790, it was a year. New Hampshire, January 25th, 1790. Delaware was January 28th, 1790. New York was February 27th, 1790. Pennsylvania, March 10th, 1790. Rhode Island, June 7th, 1790. Vermont, November 3rd, 1791. They took another year and a few months to think about it. They was like, I don't know. Virginia, they really drug their feet. They was like, and you know what? Vermont's in it. A month later, we might as well. I heard Vermont's in it. We'll take it. December 15th of 1971. Of what? 1791. The 2 amendments that were not ratified prescribed the ratio of representation to population in the House, and specified that no law varying the compensation of members of Congress should be effective until after an intervening election of representatives. The first was ratified by 10 states, one short of the requisite number, and the second by 6 states. Subsequently, the second proposal was taken up by the states in the period of 1980 to 1992, and was proclaimed as ratified of May 7, 1992. Connecticut, Georgia, Massachusetts ratified the first 10 amendments in 1939. Where am I at? Wait a minute. Yeah, Georgia hadn't even come on the scene yet. So where are we? So the two were not ratified. Prescribed a ratio of representation to population. Varying the compensation of members of Congress should be effective. Okay, so that's the one that was ratified in this section. So they cannot vary the compensation until after an intervening election of representatives. So that's the second one that was done. They were saying, like, look, you can't change someone's pay until a new election has taken place, because they signed up for the job for that 2 years based on that pay. I reckon. So how long have we been going? That's important to note. 11 minutes. We can dive into the third. It's not that long. So we have, yeah, let's take a break